Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. I am, of course, attorney Andrew Branca for The Law of Self-Defense. Come on in, come on in. Today's show is an open access show, so we're streaming on YouTube, Rumble, Twitter, and, of course, to our Law of Self-Defense members on the Law of Self-Defense dashboard. But only for the first 30 minutes or so is this open access. At the 30-minute mark, we're going to shut off the YouTube, Rumble, and Twitter feeds, and the remainder of the show will be limited exclusively to our Law of Self-Defense members. So if you're a Law of Self-Defense members, when we say goodbye to the other platforms, don't go anywhere. The stream will stay live for you. In particular, we have a number of, so today's show is a Platinum Q&A show. Our Platinum members, Law of Self-Defense Platinum members, which is our highest level of membership, their biggest benefit they get is those are the only people who have access to me for a legal consult in the event they're compelled to defend themselves, their family, their property, and find themselves criminally charged or civilly sued. We don't take outside consults anymore. We only do our legal consults for Platinum members, and they get that consult for free. Before that, the minimum was $10,000 retainer, and it goes up from there for a consult, but we stopped taking outside consults. We only do consults for our Platinum members. They get those for free. But another benefit of being a Platinum member is they get their own Platinum Q&A form where they can submit questions to me personally. And I'll answer those questions either in private to them if they request, or we answer them in the context of these Platinum Q&A shows. And then we also send individual replies to them as well to make sure they get them in case they didn't have an opportunity to actually see the show today. And a number of the questions that were sent in involved videos from the internet, as you might imagine. One of them was this fellow. This is a internet prankster, social media prankster, who does a variety of reckless things. In this case, he walks randomly into other people's homes. This occurs in England, but we'll address it as if this foolishness were occurring in the U.S. We had a question about a robbery that actually took place, I think 6 years ago now, in Tulsa, Oklahoma. A guy goes into a liquor store with a sawn-off shotgun, robs the two women who operate the store, and they beat him in a gunfight. But there's a lot of questions, less so legally, although there are a few legal questions. That's how it came up, but also tactically, if this was a prudent thing to do, the manner in which they defended themselves lawfully against this armed robber with the shotgun. And we also have a question about the Memphis homeowner who went out into the street to stop people from robbing his vehicles at 2 a.m. or so in the morning. We actually did a whole show on this just recently, but I'll share the video of this event again with today's Platinum Q&A show and point you back to where we covered it a week or so ago in a full show. But all these will be videos, and all the videos will be after the point at which we've cut off the public streaming. So if you would like access to the Law of Self-Defense member only portion of today's show, we'd be glad to provide that to you. The good news is Law of Self-Defense membership is dirt cheap. In fact, you can try it out for only 99 cents for 2 weeks. Get unlimited access to all our members only content. That's years and thousands of hours of videos. There's blog posts, there's podcasts, member only podcasts. Get unlimited access to all that for 2 weeks for just 99 cents. And if you like it and decide to stay a member, and virtually everybody does, it's it's about 30 cents a day to be a standard member of Law of Self-Defense, folks. Less than $10 a month. And you get more than double the content that we otherwise make publicly available. The content being, of course, my legal analysis, insight, expertise on self-defense law as it's applied to real people in the real world, which is the only way to effectively educate yourself on how those laws are likely to be applied to you if you are compelled to defend yourself, your family, or your property. Also, I wanted to follow up on a more general question that had come in. We have this offer we've been making for our Platinum membership. Remember, that's the membership that gets you my legal consult, the only way to get my legal consult, and for free if you find yourself criminally charged or civilly sued in a use of force event. I don't want to do a deep dive into that. You can find that at the link I'll share right here. Actually, it's at the bottom of the screen. But we put together a bundle, which is 5 years of that platinum coverage, and which normally would be $3,000 by itself, plus $3,000 of our educational content. Every course, every book, in every format that we have offered, we make available to you. And all that educational content is free. And we cut the cost of the 5-year platinum in half, from $3,000 to $1,500. Over 5 years, that's 82 cents a day, folks. That's 82 cents a day to have guaranteed platinum coverage, my legal expertise at your beck and call. If you need a legal consult and use to force a case for free, 82 cents, and you get $3,000 worth of our educational content for 82 cents a day. Now, I'm mentioning this now because technically this offer was supposed to end already, but we had a question yesterday in one of our members-only shows. This package, this bundle I'm describing right now, covers not just you, but also your spouse. And that alone would be another $700 or $800 worth of value right there. The spousal coverage is added here for free as part of this 82 cents a day offer. Someone asked, they said, well, I don't have a spouse, but I'd love to take your law of self-defense instructor program, which is like a law school level semester-long program on self-defense law for firearms and self-defense instructors. And that happens to be a little bit more, about $100 more than the spousal coverage. But they asked if they don't have a spouse, can they take advantage of this 82 cent a day offer, but do away with the spousal coverage and instead add in the law of self-defense instructor program. And we are going to make that possible. So if you'd like to take advantage of this 82 cents a day bundle for platinum coverage, but instead of the spousal coverage, get the law of self-defense instructor program, you can do that. Just email support@lawofselfdefense.com. Tell them that's what you'd like to do. We've informed them to make this possible, and they'll handle all that for you. Make sure that's all arranged properly. So there you go. By the way, just in the last couple days, as an example of the members-only content that only Law of Self-Defense members get, yesterday we covered a case in which with body camera video from the police, in which the police shot a woman in Denver 30 times between two officers. One cop did a reload and kept shooting most of those shots while she was laying on the ground. So we did a legal analysis of why the local prosecutor, no conservative in Denver, and this was Denver PD who shot that woman, why the local prosecutor decided not to bring charges against those officers, despite the volume of fire. By the way, they only hit with about half those rounds. And another members only show we did a couple days prior had to do with the Charlotte bus gunfight, which you probably read about in the news. So we did a full hour and a half or so legal analysis of that event with all the video from the event. So that's the members only content that you only get if you're a Law of Self-Defense member, folks. All right, so let's begin to dive into the meat of today's show with our little intro video. Here we go. All right, so these are platinum questions that were sent in by our platinum members, and we'll go about, I'm not going to count the first 10 minutes of today's show, but we'll go about 30 minutes in from here. Open access, everybody can watch for free, and at roughly the 30-minute mark, I will cut off the YouTube, the Rumble, and the Twitter, and just continue for Law of Self-Defense members. Again, you can become a Law of Self-Defense member for 99 cents at lawofselfdefense.com/trial. In fact, I'm going to set a little alarm for myself. 30 minutes out. There we go, folks. Okay. So, platinum member question. This is about this is from Law of Self-Defense platinum member Miles. He says he's been watching the Travis Rudolph first-degree murder trial out of Florida. So I should, Miles here provides a written description of the trial. So I'll just read it from his question. Travis Rudolph, I guess, is a retired NFL player. He claims stand your ground self-defense. Your analysis of this incident would have been LOSD gold. I may still cover it. We'll see. 4 thugs show up at Rudolph's house. Rudolph is the defendant. At midnight and brawl with him and his brother, 4-on-2. Text messages between the thugs said, "Go shoot." At some point, Rudolph retrieves a... We don't need this anymore. Hold on. Let me take this. At some point, Rudolph retrieves a .223 rifle and fires 38 rounds into the bad guys' cars as the bad guys are leaving on camera. 3 guys were in the car, 1 was killed. So that's the first-degree murder charge. The defense is implying that they tossed their guns over a bridge on a non-direct trip to the hospital. I guess no guns were recovered in their car. Their car died. The 4th thug also hit, ran from the scene, and ditched his pistol. It was found. So we know the bad guys had at least 1 gun. No vehicle DNA analysis, minimal trajectory analysis, undisguised police contempt towards the defense. Yeah, I've heard this is a very weird trial. It has been streamed live, but I haven't been covering it. Apparently, a lot of the state's witnesses are basically treating the defense with open contempt in court, is what I'm hearing, or kind of astonishing demeanor for people generally in trials, especially a whole group of people. Poor police investigation, no canvas for additional tossed weapons, no vehicle print analysis. Yeah, you already covered that. Police said there was no probable cause for thug phone analysis. Defense objected. The judge asked questions of the witnesses to clarify objections, but seems to be reasonable. But, and here's the meat of things, Travis Rudolph fired long distance at the car as it drove away. No bueno. He's guilty of something, voluntary manslaughter. So, of course, the question is, when you're firing the shots, do you have a reasonable perception that you're facing an imminent unlawful death, threat of death or serious bodily injury, or someone else's? Is that possible here? A car's driving away from you and you're firing 38 rounds of rifle at them. It seems unlikely, right? It takes... you can fire rounds pretty quick, but 38 rounds is a lot of rounds. Is it credible that you still have, with that 38th round, have a realistic fear, a reasonable fear of unlawful, imminent, deadly force harm, even if the people in the car had handguns? It's possible, but it begins to stretch credulity. That's the problem. Now, he's charged with first-degree murder. What might an argument be here? It might be... voluntary manslaughter, heat of passion manslaughter, where because of heat of passion manslaughter is when you commit a killing that's unlawful, that would otherwise be murder, but you did it in the heat of passion. There was adequate provocation by the other party that gave rise to a hot-blooded killing as opposed to a cold-blooded killing. The law says under that adequate provocation, you actually lost the ability to form the specific mental intent to kill required for first-degree murder. And the result of that is what would have been a murder conviction becomes a manslaughter conviction. And often how this works procedurally in court is first you would be convicted of first-degree murder, and then the defense has to argue to the court that this heat of passion mitigating factor, and try to get the murder mitigated down to manslaughter. And manslaughter is no walk in the park, typically 20-year sentence, but you may serve only a third of that, get released on parole. First-degree murder is typically life in prison or potentially capital, but I don't believe this is a capital case. So that's one way that this could be mitigated from first-degree murder. Another argument, and that would be voluntary manslaughter, right? It's a voluntary killing. It's not involuntary. It's not a reckless manslaughter. It's voluntary, but under adequate provocation. And the adequate provocation here would be presumably the brawl, whatever the bad guys did that would heat one's blood, right? Maybe a display of weapons, maybe knowledge of previous threats, and so forth. Another way to get to a similar outcome that's kind of a parallel path to the heat of passion voluntary manslaughter argument would be the imperfect self-defense. Imperfect self-defense is when you have an otherwise. So self-defense is normally a perfect defense, meaning that if successful, when you argue it to the jury, it leads to an acquittal, not reduced criminal liability like we just had with voluntary manslaughter, but no criminal liability. What you did was not a crime. It was legally justified. That's a perfect self-defense. Imperfect self-defense is when you almost have perfect self-defense, but one of the elements of self-defense is, of course, reasonableness, which is twofold: subjective and objective. Subjective meaning you had to have had a genuine good faith belief that you needed to use deadly force in self-defense, and objective, that genuine good faith subjective belief had to also be objectively reasonable, meaning that a theoretical, reasonable, and prudent person in those circumstances would have shared that subjective belief in the need to use deadly force in self-defense. Imperfect self-defense can arise where you have an otherwise perfect claim of self-defense, except that your subjective belief in the need to use deadly force was objectively unreasonable. So a theoretical, reasonable, and prudent person in your circumstances would not have shared that subjective belief. Your subjective belief is irrational, speculative. It's not objectively reasonable. And the effect of that is you can't qualify for an acquittal with that defense, but you can end up in a position where imperfect self-defense can mitigate, again, what would have been a murder conviction down to a manslaughter conviction. And I expect that's what they'll do. I haven't been covering this trial as it's been live streaming, frankly, because it looks so little like genuine self-defense, but maybe I'll go back and cover it if next week is slow or something like that. I'll have to take a look. But if you're firing 38 shots, folks, you better have a damn good reason. That's a lot of rounds. And it stretches credulity that you needed that 38th round. Again, technically, the black letter of the law is you can continue using defensive force as long as you continue facing that imminent threat of unlawful deadly force harm. But you have to convince other people that your belief was an objectively reasonable belief. Other people are judging your conduct, right? Your legal fate is not determined by what you believe was objectively reasonable. It's determined by what other people, the police, the prosecution, the judge, the jury, what they think was objectively reasonable. So, and they may disagree with you. And if they disagree and they conclude that your perception of the threat was objectively unreasonable, you lose the element of reasonableness, you lose perfect self-defense, and now you're kind of on your back foot hoping to get imperfect self-defense or hoping to mitigate down the voluntary manslaughter. It looks like a voluntary manslaughter killing to me, frankly, given the brawl. If he was aware of prior threats, if he was aware that the other guys were in possession of guns. But I guess we'll see. So that is Paul. That is Miles. I want to make a little note of the time so I can send Miles a link to his answer. Next, we have a question here from Goldpan. I just have an email here. It says, I like to pan for gold at the river. I'm alone except for my dog. Some goon shows up, tries to hurt me, and I end up killing him in self-defense. I'm charged with murder. No one else was there. Now what? Well, nothing's really changed, of course, except for the evidentiary landscape. And now, because you're the only witness, a prosecutor may perceive ambiguity in the facts here. They may look at because there's always another witness. Even in this scenario where it's only you and the bad dude, you shoot the bad dude, he's dead. It's you and your dog. Your dog's not going to testify. But there's still more than one witness, right? Because there's the forensics evidence. There's physical evidence. There's other things the courts can look at. There's your social media background. There's if there was a pre-existing relationship with this person. It's often hard to know whether or not there's other witnesses. Maybe there's a game camera mounted on a tree. So you should always presume there's other witnesses of some kind, evidence that might corroborate your claim of self-defense or might contradict your claim of self-defense. So for a prosecutor, the question is, they're going to receive an investigative report about this event. And when they're looking at the report, they know it's going to be a self-defense case on your part. They know it's their burden to disprove self-defense beyond a reasonable doubt. They know, well, they may not know technically because they may be poorly educated on self-defense law, but ultimately what they'll have to do, whatever state they're in, is to disprove any one of the required elements of self-defense beyond a reasonable doubt. And if they look at that investigative report and they believe they can do that, then it would be ethical for them to bring charges, seek an indictment, take you to trial, and make that legal argument to a jury. Whether or not, and we're presuming for the moment they're an ethical prosecutor and they're limiting their decision making to the boundaries of the law and the actual evidence. Whether or not they believe they can do that is largely going to be a function of the evidence. I mean, the law is pretty static. The same law of self-defense, use of force law applies in every case. So it depends on the mix of evidence you give them. And small changes in evidence can make big changes in outcome. How did they perceive the trajectory of the bullet wound tracks in the victim, for example? Are there marks in the ground that someone could interpret to suggest that it looks like an execution type killing? Did the bad guy spin away from your gun when he saw the muzzle and you ended up shooting him in the back a lot? What was the distance between you and him? And might the prosecutor interpret that distance as being sufficiently great that you were not yet in danger of deadly force harm from this unarmed aggressor that you shot and killed? So this is all the analysis, but the fundamental question is always the same. It's always these 5 elements. Did you reasonably perceive that you are facing an imminent unlawful threat of death or serious bodily injury? And then, of course, if you're in one of the 11 duty to retreat states, could you have safely retreated rather than have used self-defense? You're going to argue yes to all of that, and the state has to overcome that argument on at least one, but only one, any one of those elements of the claim of self-defense. All right, next we have Jonathan. Let's see. Jonathan says, Andrew, I listened to your legal analysis of the prankster dumping gasoline that was really water over a truck hood. Yeah, we covered that last week, I believe. Let me see. Those of you, I can't remember now if it was a members only show. Let's see. No, it looks like it was open access, May 24th. So you may be able to find that on YouTube. If you're a Law Self-Defense member, just go to lawselfdefense.com/blog. That's where we place the replays of all our live streams. You can find it there. It's the May 24th show. You didn't answer what was, to me, the most obvious question. Was the old man's action of drawing a pistol and keeping it pointed at the ground a lawful action? Was he on safe legal ground in doing that, or could he have been prosecuted? He never pointed the pistol at the bad guy, only at the ground. Okay, great question. So, unfortunately, there's a lot of ambiguity in the law here. Anytime you make someone else aware that you have a gun and you're prepared to use it for the purpose of changing their behavior, you've arguably committed aggravated assault with a deadly weapon. That's what aggravated assault is, putting someone else in fear of imminent deadly force harm. When you tell someone, hey, I've got a gun, stop what you're doing, you're threatening them with imminent deadly force harm. That's what you're doing, to make them stop what they're doing, to encourage them to stop what they're doing. And of course, then you would say, but I did that in self-defense. They were threatening me with deadly force first. And that's fine. That would be the legal defense you would raise if you were charged with aggravated assault with a deadly weapon. But that is the legal risk you've now incurred. And ag assault with a deadly weapon in most states is good for 10 years for the ag assault and another 10 years for the gun sentencing enhancement if the deadly weapon was a gun. So that's the risk you're incurring. I urge people not to let others know that you have a gun and are prepared to use it for purposes of changing their behavior, unless the situation would justify you in actually using it to change their behavior. Because then when you're incurring the risk, this ag assault with a deadly weapon risk, it's because you really have to, right? Now you're being compelled to defend yourself or your family. As a practical matter, this is not in the black letter law, but as a practical matter, most prosecutors' offices don't treat all defensive displays the same way. A lot of them will have a set of informal rules that basically say, hey, if you told someone you had a gun, we'll treat it one way. We won't treat it as aggravated assault with a weapon. If there's any view of the facts that would suggest you were telling them that for reasons you believed and possibly even were lawful, like there was some kind of threat to you. If you show them the gun in the holster, you pull your jacket back. That's a higher level. If you draw the gun from your holster, so it's in your hand out of the holster, that's yet a higher level. If you bring it to a low ready, that's a higher level. If you actually point the muzzle at them, that's when we're going to start to call it aggravated assault with a deadly weapon that you'll have to justify as self-defense. And then, of course, the next step would be firing the gun. Then you're actually explicitly using deadly force. But these are policies. They're not the law. If someone came up to you and said, give me your wallet, and opened up their jacket and showed you a gun tucked in their waistband, would you consider that aggravated assault, part of a robbery? They're putting you in fear of imminent death or serious bodily injury to change your behavior? Sure you would, of course. So the mere display of a gun can be aggravated assault. And if a prosecutor wants to be aggressive, if someone's just walking around for no good reason, opening up their jacket and showing people a gun in their waistband and putting them in fear of imminent deadly force harm, I think most of us would say that guy needs to be charged with aggravated assault. You can't just do that. He's just scaring people with a gun, right? So in that show we did where the prankster, and by the way, we have a platinum, it's not really a question, a platinum member sent in that chastised me rather severely for calling this guy merely a prankster, the gentleman with the gasoline. He's pouring apparent gasoline on the hood of someone's car. The driver of the car, a pickup truck, driver of the truck gets out and he's got a pistol held down at his side. That's a pretty conservative way of making someone else know that you have a gun. And of course, it's in the context of someone who's apparently pouring gasoline on your car. So to me, there's always a risk of prosecution. Always. If the prosecutor wants to get aggressive enough and you've opened the door a hair, they can kick the door open and prosecute you. So could that pickup truck driver be prosecuted here? If a prosecutor wanted to, sure. Remember, what does he have to do to get you to trial? He's got to pass a grand jury? Well, the grand jury is only going to hear his side, the prosecutor's side of what happened. And of course, unfortunately, not that this should matter, but this is the world we live in. The truck driver was white and the prankster was black. So how might a racially, politically motivated prosecutor add that to the equation for the grand jury? He only got his gun out because the other person was black. That's the only reason he did it. He's a racist. It's a hate crime. Sure, a prosecutor can make that argument. In terms of the defender, I think the biggest thing to keep in mind in terms of a kind of tipping point that makes your defensive display of a gun more or less defendable is whether the threat you were defending yourself against or the apparent threat you were defending yourself against. Does it matter here that the liquid in the gas can was water? Does it matter in terms of the defense justification? No, of course not. If you would reasonably perceive it as gasoline, it's gasoline for purposes of use of force law, just like if it was a realistic looking fake gun. So the kind of the tipping point is when you do that defensive display of the gun, you get the gun out in your hand. Let's say it's pointed to the ground like this truck driver did, but the gun's out. The other party knows you have a gun. You want them to know you have a gun because you're trying to change their behavior. When the gun comes out, is the threat you're defending yourself against, presumably it's not already an imminent deadly force threat, or you'd be shooting, right? You're not shooting yet. So it's not yet an imminent deadly force threat. But if you don't do something to change their behavior, does it appear that it would inevitably become an imminent deadly force threat? Or is it the kind of threat that would not be an imminent deadly force threat, no matter how much it advanced. So a different illustration than the gasoline one that may be useful. So someone is threatening to kill you. I'm going to kill you. And they're 100 yards away from you. And they have a crowbar, a big metal crowbar. And they're shouting at you. There's no question you're the party threatened. They have a grievance with you, whatever the case may be. And they're slowly moving towards you. Well, when they're 100 yards away, they're not yet an imminent deadly force threat. But when they're 7 yards away, under the tool or drill, maybe a little further, maybe a little closer, depending on the circumstances, there comes a point when they're close enough to bring that crowbar to bear in a deadly force fashion, unless you get your gun into play, right? So if nothing is done to interrupt their advance, at some point, inevitably, they will become an imminent deadly force threat. I think in that scenario, the defensive display of a gun, which I really don't encourage, but in that scenario, the defensive display of a gun is robustly legally defensible. Doesn't mean you won't be charged. Doesn't mean you won't be convicted, but that's the strongest scenario in which you would have a robust legal justification for that defensive display of the gun. Where people tend to get into trouble is where the threat they're facing, even if it achieved maximum threat, would still not be a deadly force threat against them. And remember, you can't speculate about things for which there's no observable evidence. So the person who's angry at you is not a large man with a crowbar. It's a 110-pound woman with no apparent weapons. Let's say she's wearing a t-shirt and shorts. There's no realistic way she's concealing a weapon. She's in a bikini, whatever. There's no evidence from which you can infer a deadly weapon, but she's mad at you for whatever reason, and she's 100 yards away and coming closer and closer and closer and closer. Unlike the guy with the crowbar, the woman in the bikini, even if she's standing right next to you, is still not credibly, reasonably perceived as an imminent deadly force threat. So at her maximum level of threat, you still would not be privileged to threaten her with a gun. Certainly not to use a gun in self-defense. And that's where people tend to get charged with aggravated assault with a deadly weapon in the context of a defensive display. Where even if the worst outcome of that scenario occurred, you still wouldn't be privileged to go to the gun in self-defense, and you're waving it around. So that's the answer to that question in the terms of a legal analysis. Okay, next super chat. From Paul. Paul asks, can simply openly carrying or displaying a gun on your own property during a verbal confrontation be considered a crime? What if the verbal confrontation is part of an effort to get trespassers to leave your property? And he's asking about this because there was a recent Court of Appeals decision out of Florida involving a defendant he wasn't convicted, but he was denied immunity in a Florida self-defense immunity hearing, and he appealed the denial of that immunity to the Court of Appeals. And the Court of Appeals, this is just last week. I think the case is Burns v. State, but it's sufficiently complex that I'm going to cover the Court of Appeals decision on this question in a full-length show next week. So it's on our topic list for next week. But basically, the homeowner was confronting people who I believe were cutting trees on his property. There was a verbal confrontation. At one point, the homeowner retrieves a handgun from his house, comes back out with the gun in hand, cycles the slide, never points the gun at them. And he was criminally charged, I believe, with aggravated assault, because he put the tree cutters in fear, reasonable fear of imminent deadly force harm. Just the scenario we were talking about, right? And he sought a pretrial self-defense immunity hearing. So this immunity hearing is a pretrial hearing that occurs before you go to trial, where in Florida you have an opportunity to argue to the judge, the same judge who'll be your trial judge, but it's before the trial starts, to argue to that judge that your conduct was lawful self-defense. And if he agrees, then, and I'm not going to get into details of burdens of proof here, but if the judge agrees that what you did was lawful self-defense, he can grant you immunity from prosecution, and you don't go to trial. You're immunized against prosecution. But in this pretrial hearing, of course, the state can argue against your position of self-defense. And so this defendant, Burns, requested this pretrial immunity hearing, argued before the judge. And the judge ruled. Now, keep in mind, there's no jury here in this pretrial hearing. There's no jury until the trial. So the judge is acting as both the finder of law and as the finder of fact. The role that would be that of the jury at trial. And the judge decided that as a matter of law, that the conduct of the defendant was criminal aggression. In other words, it wasn't even a question of finding a fact. The facts as conceded by the defendant, the retrieving the gun, displaying it openly, cycling the slide, even though he never pointed at anyone, was as a matter of law, unlawful criminal aggression. And so he denied immunity. And the defendant appealed the denial of the immunity. And the Court of Appeals reversed that denial of immunity. In fact, they granted immunity. They didn't just remand it back to the hearing judge. They actually just granted immunity themselves. They put a writ of prohibition on the continuation of the criminal proceedings against the defendant. But I would caution that, again, small changes in facts make for large differences in legal outcomes. And this Court of Appeals ruling, I would not take that as a blanket permission to just be waving your gun around on your property at people, or even necessarily doing what this guy did. Because it's not just his own conduct that has to be considered, it's the conduct of the tree cutters, for example. So maybe they said things or did things or were themselves aggressive in a way that the Court of Appeals says justifies this display of the gun and cycling on the slide, but a package deliverer would not have engaged in that conduct. And so the same display and cycling of the slide under slightly different facts may not be legally justified. So, but we're going to go over that case in more detail next week in its entirety, the whole decision. Okay, next question. Dave asks, is California a hard stand your ground state or just a regular stand your ground state? So, there's 11 states in the country that are duty to retreat states. And they say before you can use deadly force in self-defense, if you have a safe avenue of retreat, you're required to take it. That's the element of avoidance among the 5 elements of self-defense. 39 states are not duty to retreat states. They don't make that a legal duty, a legal obligation. But most of those 39 states, in fact, let's see. Most of those 39 states are what I call soft stand your ground states. 1, 2, 3, 4, 5, 6. There are eight. Got to get my fingers working right. 8 of the 39 stand your ground states are hard stand your ground states. And what's the difference between soft stand your ground and hard stand your ground? Well, in a soft stand your ground, there is no legal duty to retreat. So avoidance, this element of avoidance, and each of these 5 elements should be thought of as a target of attack for the prosecution, right? The prosecution needs to disprove any one of these beyond a reasonable doubt, and your claim of self-defense collapses. So if you're in a duty to retreat state, avoidance is a target of attack. You fail to take advantage of a safe avenue of retreat. If you can prove that beyond a reasonable doubt, you lose the required element of avoidance, you lose self-defense. Most of the states, 39 states, are stand your ground states. They don't impose that legal obligation. So avoidance in 39 states is off the table as a target of attack for the prosecution in an otherwise lawful case of self-defense. But in 31 of those states, the soft stand your ground states, the prosecutor can't argue, ladies and gentlemen of the jury, this defendant violated a legal duty to retreat. There is no legal duty to retreat. We're proud stand your ground state. But the prosecutor can still argue, but ladies and gentlemen of the jury, that's the time to cut off the public part of the public access part of today's show. But I'll finish this question before we go. In 31 of the states, the prosecutor can argue, ladies and gentlemen of the jury, there's no legal duty to retreat in this state. We're a proud stand your ground state here, but this defendant could have safely retreated and didn't safely retreat, and a reasonable person would have. And therefore, the defendant's conduct was unreasonable. and they lose the element of reasonableness, and therefore you should find they've lost self-defense. It's kind of a backdoor way of attacking a failure to retreat, even when avoidance itself is not technically on the table. Those are the soft stand your ground states. The hard stand your ground states, the 8 of those, their law says that the finder of fact, the jury, typically in a jury trial, or the judge in a bench trial, the finder of fact is not permitted to consider the option of retreat in evaluating the reasonableness of a use of defensive force. So in the hard stand your ground states, stand your ground is literally completely off the table. Now, I'll tell you, California is a soft stand your ground state. So the prosecutor in California is allowed to make that reasonableness argument. If you'd like to know what the 8 hard stand your ground states are, well, that's easy enough. All you have to do is be a law of self-defense member, and we have a standing blog post on that. Here it is, the 11 duty to retreat states. We update this if there's ever a change in law. So that number does change. It used to be higher. And we list all the duty to retreat states. We list the stand your ground. Sorry, we list the duty to retreat states because it's a shorter number. All the other states are stand your ground, and we list the currently eight hard stand your ground states. And you can find this at lawofselfdefense.com/retreat. Lawofselfdefense.com/retreat, but it is locked down for law of self-defense members. So you have to be a law of self-defense member to access that. And of course, why wouldn't you be when law of self-defense membership is 99 cents and it gets you not just that standing blog post, but thousands of hours, hundreds of blog posts, thousands of hours of video analysis, podcast analysis, written blog posts, for 99 cents for 2 weeks, and then 30 cents a day after that if you stay a member. Take advantage of that at lawofselfdefense.com/trial. All right. So, folks, that, my friends, ends the open access portion of today's show. If you're a law self-defense member, don't go anywhere. Don't go anywhere. We're going to stay. I have more platinum questions to answer for you. But if you're live streaming this for free on YouTube or Rumble or Twitter, this is the end of the show for you. Thank you for coming. Please consider becoming a law self-defense member. Obviously, you get a lot more content than just the free stuff at lawselfdefense.com/trial. I'm going to play a little outro. Law self-defense members, don't go anywhere. I'm staying here for you. But for all the rest of you, have a great and safe weekend. Remember, if you carry a gun so you're hard to kill, make sure you know the law so you're hard to convict as well. Take care.